Hello. We have a visitor, Vice Chancellor Samuel Glasscock, Vice Chancellor of the Court of Chancery of the state of Delaware, visiting the Markkula Center for Applied Ethics at Santa Clara University. Vice Chancellor, thank you for being here.
Thank you. It's my pleasure to be here. Appreciate the hospitality you've extended to me.
Vice Chancellor, the Court of Chancery has an important role in setting standards of corporate governance. And the court's law seems to be built around three concepts: fiduciary responsibility, standard of care, and the standard of loyalty. Can you help us understand how those are the core of Delaware's corporate law?
Fiduciary responsibility is a very broad term, and it applies broadly to trustees, to the executors of decedent's estates, to guardians of wards. And it is our traditional focus in the Court of Chancery, has been since before corporations were anyone's concern, hundreds of years. When corporations began to be a primary business organization, if you'll notice, the relationship between corporate officers and directors and the stockholders is precisely the same as between a trustee and the beneficiary of a trust. That is, one holds the property, but he holds it for the use of another. So it was natural that these fiduciary duties that were traditionally applied to fiduciaries would apply also to corporations. It's a broad term. Fiduciary just means loyalty, basically, broadly, loyalty. The duty of care and the duty of loyalty, in a smaller sense, apply to the duty of corporate directors and officers. The duty of loyalty simply means that the directors must act in their interest of the stockholders who own the corporation, not for themselves. When there's a conflict between those two, then they have to make sure they act in the best interest of the stockholders. And we don't have time to go into all the ramifications of that, but that's writ very simply the duty of loyalty. The duty of care simply means that if you're going to act as a fiduciary, you have to act as a careful and informed fiduciary. And if you fail to inform yourself and take actions to the detriment of the stockholders because you failed to inform yourself, you've breached that duty.
And the Court of Chancery is known as a court of equity rather than a court of law. What does that really mean?
For historical reasons, courts of equity came into being in England, obviously, originally, in order to provide remedies that weren't available at law. Chief among those was the duties, as I've described, that apply to trustees, to fiduciaries. So courts of equity have certain characteristics. They can issue positive orders, injunctions, so they can prevent things from happening rather than simply giving monetary damages, which is what a court of law does. They sit without juries. And that's very important in a corporate court, obviously, because it's a specialized area of the law that lay people don't have any real experience with. So if an attorney has to educate a jury about corporate law, the most basic principles have to be explained in order for them to render an intelligent verdict. Once they're educated, they can render as intelligent verdict as any judge. But we already have that knowledge. We can act very quickly because there are no juries involved, so that we can provide remedies, if necessary, on the same day that the case is filed, and we do that with some regularity. So that's all different from the law courts. In addition, we have the expertise in fiduciary relations historically, and in Delaware, because for historical reasons, which once again we don't have time to explore, corporations at an increasing rate came to Delaware, incorporated in Delaware. It's a small court. These issues of fiduciary duty were presented to the court, and we quickly established a body of law, and obviously a fairly effective body of law, predictable body of law, because there's been a kind of a feedback loop, and Delaware is now the locus of more than half of the Fortune 500 companies.
The Court of Chancery applies the law to a set of corporate behavior issues. There are a lot of people who are now concerned not just with the legality of corporate behavior, but about the ethics of corporate behavior. Can Delaware law also deal with questions of corporate ethical behavior?
That's an interesting question, and I think the answer, to answer that question, you have to start in a more basic fashion. Law and ethics are not the same. They're directed towards similar ends, but they're not the same. And from a legal perspective, the laws can be classed into two classes: malum prohibitum and malum in se. Malum in se laws are things that are ethically wrong, that are wrong in themselves. Malum prohibitum laws, and there are lots of them, and you could argue that they would include the SEC regulations as well as not running a stop sign, are wrong because somebody has said they're wrong. Both are important. You can't have a legal framework without malum prohibitum laws because they give a template within which you can act, a safe harbor for people's behavior. But they don't really address ethical questions. Our practice is somewhat unique because fiduciary responsibilities are really ethical in nature. And the primary ethical thrust of our corporate law is that you as a fiduciary for the stockholders, as a director, as an officer, may not act in a way that is inimical to their interest. You can't act in your interest. And if you do engage in transactions that's in your interest, it's voidable unless you can prove that it's entirely fair to the stockholders.
Vice Chancellor Glasscock, thank you very much for visiting us and for giving us an introduction to the question of the role that the Delaware Court of Chancery plays in corporate governance in the United States. There are more videos and information on corporate governance and on the ethics of corporate behavior on the website of the Markkula Center for Applied Ethics. Thank you.